And without further ado, I will pass you on to the knowledgeable, the wonderful Geraldine Fleming of Driver Tret.
Thank you very much, Gemma, for that wonderful and excellent introduction. Much appreciated. Just one slight correction. Easy questions only, please, at the end would be much appreciated. Anyone who's got very, very difficult ones, I would be very happy to take them separately. So, today's exciting subject is on letters of intent. And every single time I do a presentation to do with letters of intent, even I find out more cases that have gone through the courts on this subject area. As is normal on any of these sessions, what we have in terms of the pack is a very, very full set of notes. And at the start, we've got a little bit about the company I work for, which is Driver Tret. So we work across the engineering and construction industries. It is rare that I get to put a lovely, pretty picture on the screen so you can see some of the types of projects that we get involved in. We are a market leader in expert witness, planning, commercial, and technical issues. And importantly, a really big part of our work is dispute avoidance. And that will definitely be one of the themes running through today's session. Obviously, when things go wrong, we can also assist in terms of dispute resolution as well. Established in 1978, stock market listed with over 500 staff working worldwide. You can see on the screen in front of you a map showing the location of our offices. You might just about detect a very slight Cheshire accent going on. And yes, my local office is Hooton in Cheshire. Three main parts of the business. On the left, we have Driver Project Services, who provide people onto live construction and engineering sites. That generally is project managers, quantity surveyors, and planners. In the middle, we have Driver Tret, which is the part of the business I work for, and essentially providing a cradle to grave service onto construction and engineering sites. So at the start of a new potential project, we do a lot of work up front, looking at contract terms and conditions and providing either drafting services or contract reviews. During the course of the contract, obviously, we can assist with dealing with live issues. And then at the end, also looking at the final account. And obviously, our work crosses both the commercial and the planning delay analysis side as well. Finally, then on the right hand side, we have our expert witness division. And our experts work in quantum, delay, and technical matters as well. We have architects and engineers who work as expert witnesses on the technical side. Finally, we do have arbitrators, adjudicators, and mediators working within the business as well. I have put on a big long list of how we can help, and I've just emphasised for today two parts. So, this reviewing contracts and subcontracts, ideally before you have entered into them, that is a big part of what we do. And of course, right down at the bottom, advising on letters of intent as well. We do have a magazine that comes out regularly, and we would be delighted if you wanted to join our mailing list for this particular magazine. Alternatively, they are available free of charge on our website as well. Normally, when I'm giving these sessions live, I do tend to get a few boos from the audience because, yes, I am a quantity surveyor and I'm chartered. And also, I've worked on the main contractors side for 5 years as a site QS. Once I left a main contractor, I then joined a consultancy. I completed my law degree over 4 years and also did my solicitor's exams, but made a conscious decision not to actually qualify as a solicitor. And instead, I've stayed within construction claims consultancy because I really enjoy essentially working on the coalface with organisations such as yourselves. So, the wonderful subject of letters of intent. Why on earth do we use letters of intent? Well, I could be very, very sarcastic at this point and say it's because people can't be bothered to put the contract together, but perhaps that is a little bit too simplistic. We tend to have tied ourselves up, and I'm talking now us being um, employers, main contractors, subcontractors, with lots and lots of bureaucracy in terms of what is needed in order to put a contract in place. It needs to be signed off by certain individuals within a company, and it is actually quite hard in some situations to get the whole contract put together properly. And letters of intent are seen as a bit of a shortcut. So they tend to be used where the employer or client wants work to be commenced before a formal contract is agreed. And that could be because of pressure on start dates, or where there is a long lead in period for materials, which, of course, that second bullet point there, that's right on point there for issues that are affecting the construction industry at the moment. Importantly, there are different types of letters of intent. You must check the content. In its purest sense, a letter of intent is exactly that. It's a simple statement of intention, which is actually not binding at all. So the letter could be as simple as: Dear Fred, thank you for your quotation. We intend to enter a contract with you in the future. Lots of love, Geraldine Fleming. And so it's no more than a thing for the future. It's not actually binding the parties, it's just giving them a bit of a comfort blanket to say, yes, we are genuinely interested in what you have quoted for. I will say it is rare for the letters of intent that I end up seeing for them to be a simple statement of intention and not binding. Normally, the letters that I see would include a request for work to be carried out. It might be binding, depending on the wording of the letter of intent, and of course, depending on the party's contract. It's a little bit like if you watch A Question of Sport, that section of the television show that freezes the frame and asks the panelists what happens next. Okay, so in other words, we look at the letter of intent and then we need to find out, well, actually, what did the parties do next? Did work start? Was there a reply to the letter of intent? Was that reply accepted? The advice from the courts is absolutely clear with regards to letters of intent, that you should avoid letters of intent wherever possible. They are a dangerous vehicle to rely on for the formation of a contract. If you want to get lots and lots of legal experience, can I thoroughly recommend that you use letters of intent? Because the chances of you getting absolutely great legal and contractual experience will have just shot up significantly. If, on the other hand, you want to avoid seeing people like me regularly at your office, my advice is very simple. You should avoid letters of intent. There is no substitute whatsoever for a properly executed contract. Every single letter of intent is unique, and its meaning will be determined on a case by case basis. Now, two cases I will go back to, one in 2003 and one in 2006, essentially reiterate these points. But actually, the wording put forward by the judges in the two cases, I have to say, these are beautifully written judgments. The first one is Tesco and Costain, 2003. And the judge here says, it is part of the folklore of the construction industry that there exists a mythical beast, the letter of intent, the legal effect of which, if it is acted upon, is that it entitles a contractor to payment for what he does, but does not expose him to any risk because it imposes no contractual obligations upon him. In fact, the legal effect of a letter of intent depends upon the true construction of the communications between the parties and the effect, if any, of their actions pursuant to those communications. So I just love that wording, a mythical beast, the letter of intent. The second case, 2006, is ERDC Group and Brunel University. Letters of intent come in all sorts of forms. Some are merely expressions of hope, others are firmer, but make it clear that no legal consequences ensue. Others presage a contract and may be tantamount to an agreement subject to contract. Others are contracts falling short of a full blown contract that is contemplated. Others are in reality a contract in all but name. There can therefore be no prior assumptions, such as looking to see if words such as letter of intent have or have not been used. The phrase letter of intent is not a term of art. Its meaning and effect depend upon the circumstances of each case. So, the questions actually that I would want you guys to ask yourselves are set out over the next 2 pages. So, if you are working under a letter of intent or you've recently been sent one, definitely sit down and have a look at these particular questions. Number one, what is the intention of the correspondence? Is it intended to form a contract? Now, my guess would be for the majority of the ones that you receive, the answer will be yes. They do intend to form a contract, they do intend some work to be carried out. Number two, is it for the whole project or is it just for part of that project? For example, just the design, or is it just for some enabling works? Or it could even be to order some long lead in materials. And importantly, is that scope to be carried out clearly defined? Again, my normal position in relation to letters of intent is it is normally for just part of the works, but actually that scope is not clearly defined. And letters of intent, normally from the contractor, do need a response back. Number three, is there a clear agreement on the amount to be paid for that limited scope? And again, my normal situation on this when I receive these letters of intent is the answer is normally no, that there isn't a clear agreement. Normally, it's a lump of money and an ill defined scope. Item 4, is there a defined amount of expenditure? And is there reference to VAT? The VAT point, I would say it's 50-50. Half of them do refer to VAT and half of them don't. So you need to be very clear as to whether the sum stated is VAT inclusive or VAT exclusive. And if there is a cap on expenditure, spend no more than 30,000 or 50,000 or 100,000, or the one I saw a few weeks ago, which was the 8th letter of intent, which put a cap of 13 million on the expenditure of the contractor, then you must be very, very clear as to what work you are going to do. Item 5, is there a defined period of validity of the letter? Almost a James Bond clause. This letter will self-destruct on the 30th of October. And again, you have to be very clear that if you carry on working after the letter of intent date has expired, then you are potentially in a no man's land. Item 6, will the letter of intent be signed by both parties, or has it already been signed by both parties? In other words, is there a clear definition as to what the parties are both letting themselves in for? And we continue on with point 7. For works that are being carried out under the letter of intent, Are there a set of terms which will apply to that work, such as a standard form contract, and importantly, with the relevant paperwork completed? So, if it was a JCT contract, that would be the completion of the contract particulars, articles, and recitals. If it's an NEC contract, of course, it's contract data part 1 and part 2. And do the standard form terms cover issues such as insurance, copyright, governing law, and dispute resolution? Because if there is a dispute under the letter of intent, where are you going to go to resolve that? Item 8, probably in 30% of letters of intent that I look at, this is a problem. The letter of intent should be sent by the paying party or the check writer. It should be issued by the employer who you intend to be in contract with, not by the employer's representative, the project manager, or the architect. It should be sent by the person who is actually going to pay you. Item 9. Is there a list of items that remain unresolved, such as the level of delay damages or the requirement for PI insurance? And actually, what is that going to mean for the work that you are carrying out? Can you actually sensibly and safely do that work with those items unresolved? Finally, here, item 10. Now, I do start this sentence with the word if, but I probably should start it off with the word when. So, when the meaning of a letter of intent is unclear, reply clarifying any of these unclear issues. And I would then want you to wait for confirmation that your understanding is correct before proceeding. So resolve the issue about insurance or VAT or the cap, because actually, quite often, the cap is not big enough for the scope of work that has been stated. Now we have a number of cases to look at, and hopefully, through looking at these cases, my intention is certainly that you are going to be frightened off from using letters of intent going forward. But maybe my hope is too great here. The first case is Molam and Steneline back in 2004. I have to admit, a case close to my heart. Not only do I intend to use this ferry terminal this coming weekend, because this ferry terminal is at Holyhead in North Wales, but also I can proudly say that my dad worked on this job as well as one of the JCB drivers. So this was all about the construction of a new ferry terminal. Would you believe on this particular project, one letter of intent was not good enough for these two parties? No, there were actually 14 separate letters of intent issued. And the letters were pretty similar, and they came one after the other. And the final letter included a cap on expenditure of £10 million. Molam completed the work and actually spent more than the £10 million cap. Obviously, Molan put in an application for payment demanding more money, and I think it was in the region of about 11.1 million that they actually spent. Molan put in the application for payment but weren't paid, and so off they went to court seeking payment of the outstanding 1.1 million. Unfortunately for Molan, the court decided here that they were not entitled to be paid any further monies beyond the £10 million, nor actually did they have an obligation to complete the works. But actually, they did go ahead and complete those works. So the court very firmly said here to Molam, I'm sorry, you've actually been paid all of the monies that were outstanding to you. You are not now entitled to be paid the further £1.1 million. So unfortunately here, Molam lost the case. Now, of course, this is not just purely about the 1.1 million. Because Molam lost this particular case, not only did they have to pay their own legal fees, but they also had to pay the other side's legal fees as well. I have heard that the legal fees on this case back in 2004 were in the region of £500,000 per party. We've moved on 17 years since, and so if we were faced with this case now, I can only imagine that the legal fees would be in the region of double what I have mentioned there. This case was followed by a case called Diamond Build and Clapham Park in 2008. The judge said, as part of the judgment, and I can almost hear the judge sighing as he said this is yet another case which relates to a letter of intent on a construction project. And you already know from the tone of how the judge writes this particular judgment where it's going. There was a cap within the letter of intent, and this time it was a much more modest figure of 250,000. And essentially, that cap stuck if the contract wasn't executed. Now, in fairness to the client here, Clapham Park, they did send the contract to Diamond Build, but it was never signed. Diamond Build did go ahead with the work. They placed orders for 1.5 million, and the parties acted as if the JCT intermediate form of contract was in place, but no contract was ever executed. And it was almost like they pretended that everything was okay. They issued interim applications, extensions of time requests, etc. There was then a dispute between the parties and they parted company. And Diamond Build wanted paying for all of the work they'd done, and obviously also wanted paying for their liabilities to their different contractors that they'd sent orders to. Yet again, the court reimposed the decision in the Molam and Stenerline judgment and simply said that the cap was fixed. So, in other words, that Diamond Build were only entitled to be paid £250,000 unless that they could show that different work had been ordered by Clapham Park. And unfortunately, in this case, they couldn't. So Diamond Build were only entitled to the 250,000. And again, I am sure that costs followed the event. So Diamond Build had to pay their own costs, and because they lost, they had to pay the majority of Clapham Park's costs as well. Probably one of the most famous letter of intent cases is Rts Flexible Systems, and I will shorten the name of the other party here, Muller Yogurts. Letter of intent correspondence was issued by Muller Yogurts in February and March 2005. And this letter of intent confirmed that there was an agreed contract price. It authorised RTS to carry out all work based on an agreed programme, and also said that the full contract would be based on Muller's amended MF1 contract. Now, in this case, we did have one of these James Bond clauses. So, in other words, there was a self-destruct date, and the letter of intent expired on the 27th of May 2005. The draft contract was drawn up in July 2005, and RTS carried on working throughout. It did address the main points that you would expect it to. However, there were 17 schedules to the contract which weren't completed. And importantly, this contract was never executed. It was described as being subject to contract and not binding until it was executed. RTS completed their work on site, but they didn't complete the site acceptance testing in accordance with the draft contract. Muller stated that the works contained defects and they required substantial performance. I do like the bit I've put in brackets here. Muller's barrister described the product line as like being like a scene from a Wallace and Gromit film. So I've got this impression now of yogurt being squirted out and missing the yogurt pots below. And actually, the dispute here wasn't enormous. RTS sued for what they considered to be the outstanding balance, which was about £500,000. Now, of course, after this session, I am hoping that your knowledge will be significantly increased and that you will be able to review and think about the legal consequences of the letters of intent that you are involved in. Yet I will say, in this particular case, we had 3 courts and we had 3 different decisions. At first instance, it was decided that there was a contract, but it wasn't the MF1 contract. At the Court of Appeal, it was decided that there was no contract concluded at all. This then went all the way to the Supreme Court, which is effectively the official name for the House of Lords. And here it was held that a contract did exist, and that contract did include the MF1 conditions. The judge said that whilst there were terms to be agreed, these were not essential terms and they did not preclude the existence of a contract. And essentially, here, the conduct of the parties meant that the contract was affirmed because works were carried out, payment was made, and they actually varied a contract which wasn't in existence in August 2005. Now, who won here? Well, in theory, RTS won because the liquidated damages in the MF1 amendments were limited to 2.5% of the contract price. But I guess that the vast majority of you would be able to fill in the blank on the final bullet point here. Who won? Well, my guess is probably that it was the lawyers, barristers, solicitors, and party representatives who had 3 separate opportunities to win this particular case. And I dread to think the level of costs between these 2 parties. I have a feeling here that actually each party probably would have borne their own costs. And actually, if they looked back in time, both of them would have said that it was a mistake to let it go all the way through the 3 courts. And again, let's have a little bit of, I'll say, pearls of wisdom from the judge in this particular case. Well, the judge said, the moral of the story is to agree first and start work later. I'm going to say pretty much a statement of the obvious. Before I go on any further with the next case, I will remind you that the chat is open. If you do have easy questions, please do type them into the chat and Gemma can torture me at the end of this session. So the next case we're going to look at is a rather unusual one because this time it's not between the employer and the contractor. This time the case is between the employer and their representatives. So here we've got Ampleforth Abbey Trust and Turner and Townsend Project Management, a case in 2012. The client here is the trust, Ampleforth Abbey. The main contractor was Kia and the project manager is Turner and Townsend Project Management. They had planned to use a JCT 98 design and build contract, but it was never signed. Kia started on site using a letter of intent, which was then reissued with ever increasing values. And the work was done, disputes arose, and the client said that Kia had completed late, and the client wanted to be paid £750,000 in liquidated damages. The parties, Ampleforth Abbey and Kia, settled the differences between themselves with Kia not receiving any additional money, but importantly, the client, Ampleforth Abbey, also not being able to impose liquidated damages because, of course, there was no executed contract between the parties. Ampleforth Abbey were not happy about the fact that they hadn't been able to actually get these liquidated damages back, so they sued the project manager, Turner and Townsend. And it was held in this particular case that Turner and Townsend had failed to reach the standard of a competent project manager, as the contract had not been finalised and signed off. So, in other words, they hadn't used reasonable skill and care in carrying out their duties. The court, however, didn't impose the full 750,000 on Turner and Townsend, and Turner and Townsend only had to pay 226,000 in damages to the trust. And this was based on an estimate as to the likely level of liquidated damages which the trust would have recovered, obviously taking into account extensions of time that the trust would have had to given Kia, and also the likelihood on Kia signing the contract. This case is really an unusual case because normally it's the two parties, the employer, main contractor, or the main contractor, who are fighting over the monies. Here, Turner and Townsend were the ones that were seen to have failed. Another interesting case, and we move across now to 2016, is a case between Arcadis and AMEC. But actually, if we go back in time, the two relevant parties were actually Hyder and Buchan. And this is about Bournemouth Car Park. Now, if you want to Google Bournemouth Car Park and litigation, you will see that there is an awful lot in the press about this particular job. Buchan subcontracted their design work to Hyder for a sum of 285,000. The design work was completed, the car park was built, and later defects um, were discovered. The defects, to resolve the defects, was going to cost up to £40 million. Why was the figure so high? Well, because actually it might have involved demolishing the car park and loss of revenue, and of course, rebuilding it. Now, importantly, there was a cap on the specialist design contractor's liability. There was a cap on Hyder's liability, and that cap on liability was £610,000. But the question was whether the Hyder's terms were incorporated in the letter of intent. And here we go again. We start to go through the courts. In the Technology and Construction Court, the judge here, Justice Coulson, said this was a simple binding contract and Hyder's terms were not incorporated, and therefore there was no cap on liability. The judge, Mr. Justice Coulson, said here, this case demonstrates that it is usually better for a party to reach full agreement, which in this case would almost certainly have included some sort of cap on their liability through a process of negotiation and give and take, rather than to delay and then fail to reach any detailed agreement at all. So, Hyder, the designer here, are now looking at potentially paying out £40 million for their defective design. Well, of course, Hyder then had been bought by Arcadis. They were not happy. So off they go to the Court of Appeal. Judge Coulson's decision was reversed, with the Court of Appeal judges deciding that Hyder's terms, including their, now this is not laugh out loud, this obviously is limitation of liability clause was included within the letter of intent. Therefore, Hyder or Arcadis were only liable to the tune of £610,000, with Buchan, who then had been bought by AMEC, liable for the remainder, some £39.5 million. Again, I dread to think what the costs of the two parties were in this particular case. And again, a little bit like the Muller Yogurts case, even the judges themselves can actually get these decisions wrong. We'll go back in time a little bit here to 2014. Here, rather unusually, we've got a situation between a main contractor, Volker Fitzpatrick, and their subcontractor, Twintech. The project here sounds probably the most exciting project we've looked at so far. Accolade Wines, I believe it was a wine storage warehouse, but at 20 to 10, it's probably a little bit early in the morning to be talking about wine. The employer here was claiming £170 million in damages from Volker Fitzpatrick due to specification issues. The main contractor started adjudication, applied for an adjudicator to be appointed, and what they were looking at here specifically was the costs of tests on the floor slab, some £850,000. So this is not the case involving Accolade Wines. This is just looking at the costs of tests that were carried out. The letter of intent stated that the subcontractor should carry out the works in accordance with what I can only describe as a bundle of contract documents, which did include the standard form. And of course, here it's a hokey cokey question. Was the standard form part of the bundle, and was it expressly incorporated into the contract between Twintech and Volker Fitzpatrick? The letter of intent didn't expressly incorporate any of these terms and conditions, and the court decided here that actually the letter didn't therefore incorporate the terms, and in this particular case, the adjudication couldn't proceed because the adjudicator was not validly appointed. I think that there have been more court cases about this case since, but it hit here just between the subcontractor and the main contractor about an issue of about 850,000. They weren't able to use adjudication in this particular case. And we have more cases. Whittle Movers and Hollywood Express in 2009. This actually wasn't a clear construction contract. It was a 6-year distribution contract. One of the parties thought that the contract had been concluded, and the other party said it hadn't been. Hollywood Express ended the agreement after 15 months, and Whittle claimed that the 6-year agreement had been concluded. And therefore, because Hollywood had ended the agreement early, they were entitled to damages. The court in this case said no, that there was no 6-year agreement at all, and therefore Whittle were not entitled to any damages. Another case, 2012, Merit Process and Balfour Beatty Engineering Services, and this all revolved around a letter of intent in 2004. There was a draft subcontract agreed, but there was a disagreement on the price, with one party saying that the price agreed was 1.6 million and the other party saying it was 1.637 million. So a very small amount of money between the parties. The court decided here there was no agreement on price, therefore there was no contract between the parties, and Merit was simply entitled to be paid on a reimbursement of costs basis. The final case that I want to look at today is Anchor and Midas, which is 2019. Again, we have a series of letters of intent between the parties, and yet again, works were carried out. The contract here was dated July 2014, and this was partly agreed, but there was a risk register detailing items that hadn't been agreed, in particular items that were omitted, but the parties disagreed with the status of this document and claimed that the contract, and my said, no, there wasn't. It was held in this case that there was a contract in place. The lack of signature wasn't conclusive. Yet again, communication and conduct of the parties showed that Midas intended to be bound all the way from July 2014. So again, we here look at the conduct of the parties. For almost my last slide, I just want to run through a typical bad example of a letter of intent. We start here with a date on this particular letter of intent. It's being sent to a company, and thank goodness we have here a limited company between the parties, and it is sent to an individual. So the letter actually starts quite well. Dear Sirs, Sports Centre, we confirm that you have been awarded the subcontract to design, supply, and fix curtain walling at the sports centre next to the stadium. Okay, we've got an issue here straight away about what stadium are they talking about and what sports centre as well. And that first paragraph sounds as if the job is done. We have included subcontract. But the next paragraph has some doubt on it. It says, it is our intention to enter into a formal subcontract with you using a JCT DOM1 subcontract conditions, incorporate the following numbered documents. Actually, there isn't a subcontract called a JCT DOM1 at all. So we've got doubt here again as to the conditions that apply. The documents attached are pre-con meeting minutes, UK construction specification, UK construction standard terms and conditions of purchase, a quotation from a company called InSleep, project plan. So not only have we got another set of terms and conditions in here, but we've got someone else's quotation incorporated into the contract. And we've got a problem on dates as well, because the quotation is from 2018, and this is a letter that's being sent in 2019. The letter continues. To meet the requirement of the project programme, we hereby instruct you to commence the design and commence the procurement of all materials necessary to achieve the required commencement date shown on the programme. So obviously you would need to have a look at the programme to find out when it's going to start. You also need to know an awful lot about the scope of work. All work undertaken under this letter shall be based on those terms and conditions referred to above. Well, there's several conditions referred to there, so that isn't clear either. If no formal subcontract is executed between the parties, we shall reimburse you all costs you incur, all reasonable costs. That is less than cost. Why would any subcontractor want to work less than cost? It then says, however, your expenditure shall be limited to the sum of £25,000. No reference to VAT. And actually, I don't think you could do much in terms of design and procurement for £25,000 in relation to curtain walling at a sports stadium. The final paragraph says once the formal subcontract has been agreed and executed, this will have retrospective effect and shall supersede the terms of this letter. That is normally the case, but I'd actually want to see that repeated in the subcontract as well. It ends up by saying, yours faithfully, Mike Barnes, Assistant Site Agent for UK Contracting. Well, I've got a problem here with authority. Does this person have the authority to bind their employer into this contract? I'd say the courts will probably say yes to that question. But UK contracting, when you look at the left hand side, the company name appears to be UK Construction. So again, we have a problem with that there as well. In summary, I absolutely say to everybody, letters of intent should be avoided. It is in both parties' interests to formalise and sign the contract. And you should think about using maybe a JCT minor works, maybe an NEC short contract, or an NEC cost reimbursable option E for enabling works rather than going down the line of a letter of intent. If letters of intent are used, they absolutely carry extra risk. And the parties, if they do decide to roll the dice and gamble their future, they should endeavour to agree a formal contract as soon as possible. So we have come to the end of my formal slides, and it is with a degree of nervousness that I ask Gemma to appear back and to only ask the easy questions, if any have been asked in the chat. And I'm happy to have an early coffee break, Gemma.
I think you've stunned everyone into silence. And there's a lot of panicked people running off, checking that nothing's based on letters of intent around their office. So yes, we don't have anything at the moment. We have one comment from Paul. We never learn.
I might quote that next time, Paul, actually, if I do this session again in a few years' time. So
yeah, the only other query that we've had in the comments so far is again around the slides and whether they'll be shared afterwards. So Geraldine very kindly will send those out to everyone, so I'll pass on the details of everyone who's attended so far today. I'll pass those on and then those will be sent off. But no, we have no other further questions. So everyone gets an extra 9 minutes in their day, which I'm sure everyone could use. We tend to flip between these online meetings and webinars and things. So thank you very much to everyone for attending today. Fantastic to see so many people on. You'll all have probably received the invitation to the next webinars coming up. What there will be on the information that comes out afterwards as well is there should be a link to the profile page on Click Meeting, which will have a link to all the ones that are scheduled on there. But we'll try and make sure that everyone gets a direct invitation as well. As we've mentioned, the CPD certification is also available through there to download. So fantastic. Only other comments are thank you. So that's good. We can end on that note, I think. Thank you so much, everyone. We look forward to seeing you at the next event. Thank you once again to Geraldine. Fantastic webinar, as always. Take care, and we'll see you all soon.
thank you very much. Cheers.
Thank you, everyone. Bye.
Take care. Bye-bye.